Gentleman from Kentucky is recognized.
Mr. Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
Thank you, Mr. Speaker. And I rise in support of H.R. 2515, the Whistleblower Protection Act of 2019. I would like to thank my colleagues, Congressman Green and Congressman Huizenga, for their work on this common-sense bipartisan legislation. Mr. Speaker, whistleblowers play a very important role in rooting out bad behavior that harms the market as well as mom and pop investors. Additionally, businesses have a self-interest in detecting and eliminating illegal activity as swiftly as possible within their organizations. To that end, clarifying the concept of encouraging employees to report alleged securities fraud activities to their employers without fear of retaliation just makes simple common sense. Businesses typically strive to comply with the law, and they have incentives to do so from market pressures. But it's also because unlawful activity hurts the company itself, and it hurts its investors, driving down the company's value, tarnishing the company's reputation, repelling business partners and customers, and damaging the overall marketplace. That's why, frankly, the vast majority of actors in the private sector do the right thing. But for these reasons, many companies have implemented strong internal reporting measures to detect and mitigate potential wrongdoing before harm spreads. But if internal whistleblowers who report potential securities law violations internally are not protected from retaliation, what good are these internal reporting systems that these companies have voluntarily established? That notion might seem counterintuitive, but last year in the Digital Realty Trust case, the Supreme Court held that the whistleblower anti-retaliation protections of the Dodd-Frank Act do not extend to internal whistleblowers. Only those who report to the SEC are protected from retaliation. Now, this is not an error in the Supreme Court's judgment. It's simply a faithful interpretation of the flawed drafting of the Dodd-Frank law. This bill solves this problem by amending Section 922 of Dodd-Frank to clarify that whistleblowers who report alleged misconduct internally with their employers but not to the SEC are protected by Dodd-Frank's anti-retaliation provisions. By clarifying that Dodd-Frank's anti-retaliation protections also apply to internal whistleblowers, this bill addresses the Supreme Court's interpretation and aligns Dodd-Frank's whistleblower protections with other major whistleblower laws. Again, I want to thank Congressman Green and Congressman Huizenga for this important bipartisan legislation, which I proudly support, and I urge all of my colleagues to join me in supporting H.R. 2515. I reserve the balance of my time.